Hello everyone. After the suit has been filed, we have discussed about the procedures about the suits, and then we have come to the point where we are going to appeal. When the appeal is preferred before the higher court, then what are the rights of that court and what are the powers, that also we have discussed, and what is an appeal, whether it is a vested right and whether it is a substantive right. We have discussed these provisions. Now we will go to the procedure of appeal. ನಿಜವಾದ ಅಪೀಲ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಇವತ್ತು ನೋಡೋಣ. The procedure of appeal, see, the substantive parts are given in section 96, 97, 98, 99 and 99A, and the procedure is given in order 41 of the civil procedure code. ಈಗ ಆರ್ಡರ್ 41 ನೋಡುವಾಗ, 41ನೇ ಕ್ರಮಾದೇಶ ನೋಡುವಾಗ, ಪ್ರಕ್ರಿಯೆ ಹೇಗೆ ಅಪೀಲನ್ನು ಫೈಲ್ ಮಾಡ್ತೀವಿ, ಅಪೀಲ್ ಹೇಗೆ ಕೋರ್ಟ್ ತಗೊಳುತ್ತೆ, ಮುಂದೆ ಕೋರ್ಟ್ ಮುಂದೆ ಏನೇನು ಪ್ರೊಸೀಜರ್ಸ್ ಆಗುತ್ತೆ, ಏನೇನು ಪ್ರಕ್ರಿಯೆಗಳಾಗುತ್ತೆ, ಅದನ್ನೆಲ್ಲ ಡೀಟೇಲ್ಸಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. ಸೊ ರಿಲೇಟಿಂಗ್ ಟು ದೀಸ್ ಪ್ರಾವಿಷನ್ಸ್ ವಿ ಹ್ಯಾವ್ lot of questions about it. So let us solve those questions relating to procedure of filing of appeals. Now, what is an appeal? We have seen appeal is the judicial examination of the decision of an inferior court by a higher court. Now, what is a memorandum of appeal? When you file an appeal, you file it with a memorandum. ಒಂದು ವಿವರಣಾ ಪತ್ರದ ರೂಪದಲ್ಲಿ ನಾವು ಒಂದು ಅಪೀಲನ್ನು ಕೋರ್ಟ್ ಮುಂದೆ ಫೈಲ್ ಮಾಡ್ತೀವಿ. ಸೊ ವಾಟ್ ಆರ್ ದ ಗ್ರೌಂಡ್ಸ್ ಆನ್ ವಿಚ್ ದ ಜುಡಿಷಿಯಲ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಇಸ್ ಇನ್ವೈಟೆಡ್? ಸೊ ಆನ್ ವಾಟ್ ಗ್ರೌಂಡ್ಸ್ ವಿ ಆರ್ ಆಸ್ಕಿಂಗ್ ದ ಹೈಯರ್ ಕೋರ್ಟ್ to look into the decision of the inferior court? That grounds are all set out in the memorandum of appeal. That is the memorandum of appeal. Now, for what purpose it is to be filed? You can just file an application, you would say. Why should there be a memorandum? Memorandum is a particular method of filing. ಒಂದು distinct ಒಂದು specific ಫಾರ್ಮ್ ಪ್ರಕಾರ ಅದು ಫೈಲ್ ಮಾಡಬೇಕಾಗುತ್ತೆ. ಇದು ಫಾರ್ ಪರ್ಪಸಸ್ ಆಫ್ ಲಿಮಿಟೇಷನ್ ಆ್ಯಂಡ್ ಫಾರ್ ರೂಲ್ಸ್ ಆಫ್ ಕೋರ್ಟ್, ದಿಸ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಫೈಲ್ಡ್. ದಟ್ ವಾಸ್ ಸ್ಟೇಟೆಡ್ ಇನ್ ಅ ಕೇಸ್ ಆ್ಯಕ್ಚುಲಿ, ಆ್ಯಂಡ್ ದಿಸ್ ಇಸ್ ದ ಗ್ರೌಂಡ್ಸ್. Now, what are the requirements for a valid presentation of appeal? First of all, Order 41, Rule 1 says that these are the conditions which should be specified. That is how you are going to put it before the court. ಕೋರ್ಟ್ ಮುಂದೆ ನೀವು ಅಪೀಲನ್ನು ಹಾಕಬೇಕಾದ್ರೆ, ಅಪೀಲನ್ನು ನೀವು ಮುಂದೆ ಪ್ರೆಸೆಂಟ್ ಮಾಡಬೇಕಾದ್ರೆ ಅದರಲ್ಲಿ ಏನೇನು ಇರಬೇಕು? ಫಸ್ಟ್ ಆಫ್ ಆಲ್, ಇಟ್ ಶುಡ್ ಬಿ ಇನ್ ಅ ಫಾರ್ಮ್ ಆಫ್ ಎ ಮೆಮೊರಾಂಡಮ್ setting forth the grounds of objections to the decree appealed from. See, when we file a suit, we file a plaint. That's the difference. We file a plaint. Here we file a memorandum in appeal. And in a suit, when the reply is given by the defendant, he gives it in the form of a written statement. But here, when the reply is given, it is on the ground of objection statement to the memorandum. So that is only the difference. Then there is a particular method of drafting the plaint. Same way, there is a particular method of drafting the memorandum of appeal. So what should be there in the memorandum? First of all the grounds of objections to the decree which has been appealed from. ಯಾವ ಗ್ರೌಂಡ್ ಮೇಲೆ, ಯಾವ ಆಧಾರದ ಮೇಲೆ ಈ ಡಿಕ್ರಿಗೆ ನಾವು ಆಬ್ಜೆಕ್ಷನ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ, ಅದನ್ನು ಆ ಗ್ರೌಂಡ್ಸನ್ನು ಹಾಕಿ ಈ ವಿವರಣಾ ಪತ್ರ ಅದೇ ಎಲ್ಲ ವಿವರಿಸಿ ಆ ಗ್ರೌಂಡ್ಸನ್ನು ವಿವರಣೆ ಮಾಡೋದು ಮೆಮೊರಾಂಡಮ್ ಆಫ್ ಅಪೀಲಲ್ಲಿ. ಸೆಕೆಂಡ್ಲಿ, ಇಟ್ ಮಸ್ಟ್ ಬಿ ಸೈನ್ಡ್ ಬೈ ದ ಅಪೆಲೆಂಟ್ ಆರ್ ಹಿಸ್ ಪ್ಲೀಡರ್. ಅಪೀಲ್ ಮಾಡೋ ಅಂಥ ವ್ಯಕ್ತಿ, ಇಲ್ಲೇ ಪ್ಲೇಂಟಿಫ್ ಡಿಫೆಂಡೆಂಟ್ ಅಂತ ಹೇಳಲ್ಲ. ಪ್ಲೇಂಟಿಫ್ ಹೋಗ್ಬೋದು ಅಪೀಲ್ಗೆ, ಡಿಫೆಂಡೆಂಟ್ ಹೋಗ್ಬೋದು ಅಪೀಲ್ಗೆ. ಯಾರ ವಿರುದ್ಧವಾಗಿ ಆದೇಶ ಬಂದಿದೆ ಅಥವಾ ಯಾರ ವಿರುದ್ಧವಾಗಿ ಜಜ್ಮೆಂಟ್ ಬಂದಿದೆ ಅವರು ಅಪೀಲ್ಗೆ ಹೋಗ್ಬೋದು. ಸೊ ವೆನ್ ಎವರ್ ದ ಅಪೆಲೆಂಟ್, he may be the defendant in the original case, he may be the plaintiff in the original case, on against whom that decree has been pronounced. So that person, he is an appellant, he files a memorandum of appeal, he signs it or his pleader signs it. it must be presented to the court or to such officer as is appointed. Court may appoint an officer for that purpose. That memorandum of appeal is given or is presented to that particular officer or the court. It must be accompanied by a certified copy of the judgment. This has been changed. Earlier it must be accompanied by a decree, certified copy of the decree, and if necessary the judgment. That was the earlier provision. They have changed it after 1976, and in 1999 several changes took place in this appeal provisions. Again in 2002 there were several modifications or amendments done in Order 41. So relating to appeals, filing of appeals. So it is accompanied by a certified copy of the judgment. You have to file the judgment copy along with the memorandum. Then where the appeal is against a money decree, suppose the decree is for money and you have to pay the money to the person who has, the decree holder. So then when he files a appeal, the condition is that he should deposit the decretal amount to the court first, or if he does not deposit, he should furnish the security in respect thereof, that is in respect of the decretal amount. Whatever is awarded in the decree, for that there should be a security. If the appeal it goes against him, then that security is forfeited and the amount goes to the other person, that is to the person who wins in that case. So he must deposit. So when the appeal is against a money decree, ಯಾವುದೇ ಮನಿ ಡಿಕ್ರಿಯಲ್ಲಿ ಅಪೀಲ್ ಆಗಬೇಕಾದ್ರೆ ಏನು ಮನಿ ಅದರಲ್ಲಿ ಆ ಡಿಕ್ರಿನಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಆ ಅಮೌಂಟ್ ಅವನು ಫಸ್ಟ್ ಕೋರ್ಟಲ್ಲಿ ಡಿಪಾಸಿಟ್ ಮಾಡಬೇಕು. That is the requirement under Rule 1, Sub Rule 3. Then what are the contents of the memorandum? See, the memorandum is a list of all the grounds. So what should be there in the memorandum? First of all the grounds of objections to the decree should be stated in the memorandum. These grounds should be concisely stated under distinct heads. ಪ್ರತ್ಯೇಕ ಗ್ರೌಂಡ್ಗೆ, ಪ್ರತ್ಯೇಕ ಆಧಾರಕ್ಕೆ, ಯಾವ ಆಧಾರದ ಮೇಲೆ ನೀವು ಅಪೀಲ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಅದು ಕನ್ಸೈಸ್ಲಿ, ಇನ್ ಶಾರ್ಟ್, ಸಂಕ್ಷಿಪ್ತದಲ್ಲಿ ಒಂದು ಡಿಸ್ಟಿಂಕ್ಟ್ ಒಂದು ಹೆಡ್ ಆಫ್ ಅಥವಾ ಟೈಟಲ್ ಅಥವಾ ಹೆಡ್ ಕೊಟ್ಬಿಟ್ಟು ಅದರಲ್ಲಿ ನೀವು ಅದನ್ನು ಆ ಗ್ರೌಂಡ್ ಬರಿಬೇಕು. ಅದರಲ್ಲಿ ಯಾವುದೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಥವಾ ನರೇಟಿವ್ ಇರಬಾರ್ದು. ಅದರಲ್ಲಿ ಯಾವುದೇ ಒಂದು ಸ್ಟೋರಿ ಥರ ಉದ್ದ ತಗೊಂಡು ಅದು ತುಂಬ ಡಿಸ್ಕ್ರೈಬ್ ಮಾಡಿ ಹೇಳೋದು ಬೇಕಾಗಿಲ್ಲ. ಇನ್ ಶಾರ್ಟ್, ಬರೀ ಪಾಯಿಂಟ್ಸ್, ವಿದೌಟ್ ಎನಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆರ್ ನರೇಟಿವ್ ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಸ್ಟೇಟೆಡ್. ದೆನ್ these points should be numbered consecutively, 1, 2, 3, 4, they should be numbered according to that. Then Rule 2 says that if he does not set up any ground in that particular memorandum of appeal, the appellant cannot urge that ground or any objection to the decree later on. He shall not state any grounds unless he takes the leave of the court. ಇದರಲ್ಲಿ ಗ್ರೌಂಡ್ ಯಾವುದು ಕೊಟ್ಟಿಲ್ಲ ಅಂದರೆ, ಯಾವುದೇ ಒಂದು ಆಧಾರ ಅದರಲ್ಲಿ ಬರ್ದಿಲ್ಲ ಅಂತಂದರೆ ಆ ಪಾಯಿಂಟ್ ಮೇಲೆ ಅವನು ಆರ್ಗ್ಯೂ ಮಾಡೋಕ್ಕಾಗಲ್ಲ. ಅವನು ಆರ್ಗ್ಯೂ ಮಾಡಬೇಕಾದ್ರೆ ಕೋರ್ಟಿನ ಅನುಮತಿ ತೊಗೊಂಡು ಆರ್ಗ್ಯೂ ಮಾಡಬೇಕು. ಅವನ ಆರ್ಗ್ಯುಮೆಂಟ್ಗೆ ಕೋರ್ಟ್ ಅನುಮತಿ ಕೊಟ್ಟರೆ, ಅದರಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು ಕೂಡ ಕೋರ್ಟ್ ಕೊಟ್ಟರೆ ಆವಾಗ ಅವನು ಅದರಲ್ಲಿ ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೋದು, ಇಲ್ಲಾಂದರೆ ಮಾಡೋಕ್ಕಾಗಲ್ಲ. ದಿಸ್ ಇಸ್ ವೆರಿ ವೆರಿ ಮ್ಯಾಂಡೇಟರಿ ರೂಲ್. Rule 2 says that when the ground is given, okay, the court while deciding the appeal is not confined to the grounds. That person cannot argue on any other ground, but the court will not confine itself to only those grounds. It can even look into other grounds also. It may add other grounds also on its own, suo motu. But if it adds any ground on its own, then it should give the party an opportunity to contest the case on that ground. Suppose the court ತಾನಾಗಿ ತನ್ನ ಇದರಿಂದ ಇದನ್ನು ಒಂದು ಹೊಸ ಗ್ರೌಂಡ್ ಅದರಲ್ಲಿ ಕ್ರಿಯೇಟ್ ಮಾಡಿದರೆ ಆ ಗ್ರೌಂಡಲ್ಲಿ ಕಂಟೆಸ್ಟ್ ಮಾಡೋಕ್ಕೆ ಒಂದು ಅವಕಾಶ ಪಾರ್ಟಿಗೆ, ಯಾರ ಪಾರ್ಟಿಗೆ ಎಫೆಕ್ಟ್ ಆಗುತ್ತೆ ಆ ಗ್ರೌಂಡಿಂದ ಅವ್ರಿಗೆ ಒಂದು ಕಂಟೆಸ್ಟ್ ಮಾಡೋಕ್ಕೆ ಒಂದು ಅವಕಾಶ ಕೊಡಬೇಕು. ಸೊ ದಟ್ ಈಸ್ ಎ ರಿಕ್ವೈರ್ಮೆಂಟ್ ಅಂಡರ್ ರೂಲ್ 2. See how the principles of natural justice are followed in appeal, because first of all everything should be sure, everything should be concisely stated, only the grounds of appeal should be stated, then that should be presented before the court. The court looks into the grounds, only on the grounds you can speak, but if the court allows some other ground, then the party should be given an opportunity. Next, how it is prepared. So while preparing the memorandum of appeal, what are the things we should look into? So we should first look into the pleadings while preparing it. Pleadings ಅಲ್ಲಿ ನಾವು ಏನು ಹೇಳಿದೀವಿ, ಈ ಮಾತು ಹೇಳಿದೀವ ನಾವು ಅಂತ ನಾವು ಯೋಚನೆ ಮಾಡಬೇಕು, ಆ ಪ್ಲೀಡಿಂಗ್ಸ್ ನೋಡಬೇಕು. ದೆನ್ ಸೆಕೆಂಡ್ಲಿ ವಿ ಶುಡ್ ಲುಕ್ ಇನ್ ಟು ದ ಇಶ್ಯೂಸ್. ಆ ಒರಿಜಿನಲ್ ಕೇಸಲ್ಲಿ ಇಶ್ಯೂಸ್ ಏನು ಫ್ರೇಮ್ ಆಗಿತ್ತು, ವಿವಾದದ ಪ್ರಶ್ನೆಗಳು ಏನಿತ್ತು, ಪ್ರತ್ಯೇಕ ಪ್ರಶ್ನೆಗಳ ಮೇಲೆ ಯಾವ ಫೈಂಡಿಂಗ್ಸ್ ಇದೆ, all the findings on each issue has to be considered. Then finally you have to consider the judgment in the original suit. Judgment ಏನಾಗಿದೆ ಮತ್ತೆ ಡಿಕ್ರಿ ಏನಾಗಿದೆ ಇವೆಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಆ ಪ್ಲೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿರೋದು, ಇಶ್ಯೂನಲ್ಲಿ ಕೊಟ್ಟಿರೋದು, ಅದರಲ್ಲಿ ಫೈಂಡಿಂಗ್ಸ್ ಏನು ಕೋರ್ಟ್ಗೆ ಬಂದಿದೆ, ಅದ್ರ ಪ್ರಕಾರ ಜಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದೆಯಾ, ಆ ಜಜ್ಮೆಂಟ್ ಪ್ರಕಾರ ಡಿಕ್ರಿ ಆಗಿದೆಯಾ, ಇದೆಲ್ಲ ಕೇರ್ಫುಲಿ ಕನ್ಸಿಡರಿಂಗ್ ಆಲ್ ದೀಸ್ ಥಿಂಗ್ಸ್, ದೆನ್ ಯು ಕ್ಯಾನ್ ಪ್ರಿಪೇರ್ ದ memorandum of appeal. Now once the memorandum of appeal is presented, if the court finds that it is not in a proper form as is stated here in rule 1, then it may reject it. The court may reject it, or it may return it to the appellant for the purpose of being amended. So amend ಮಾಡೋಕ್ಕೋಸ್ಕರ ವಾಪಸ್ ಕೊಡ್ಬೋದು ಅಥವಾ outright reject ಮಾಡ್ಬೋದು, ಇದು ಸರಿಯಾಗಿ ಫಾರ್ಮ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತ. Because appeal, as I said, it is a matter of the discretion of the court. It is not your substantive or inherent right. So if you don't present it according to the rules, then it is going to be rejected, or the court may look into the matter and it may give the person an opportunity to amend. So where it rejects, then for the rejection it will have to record the reasons. It cannot reject without reasons. Okay, and where it is amended, after it is amended, then the judge or the officer whom he appoints in this behalf shall sign or initial the amendment. See, these are the rules, but we find that sometimes, in my own experience, sometimes we find that suppose the court rejects, many a times what happens, it goes before the court and outright, as it is not in a particular form, the court rejects it. At that time, what are the reasons given is that in our opinion it is a right case for rejection. That is the reason given. I have seen that. So what happens is, ಈ ಥರ ಕೊಟ್ಟರೆ ಏನಾಗುತ್ತೆ, ರಿಜೆಕ್ಷನ್ ಮಾಡಬೇಕಾದ್ರೆ, ಇಫ್ ಇಟ್ ಇಸ್ ಅದನ್ನು ತಿರಸ್ಕರಿಸಬೇಕಾದ್ರೆ ಅದರಲ್ಲಿ ಏನಾದರೂ ಒಂದು ಗ್ರೌಂಡ್ ಇರಬೇಕು, ಅದರಲ್ಲಿ ಏನಾದರೂ ಒಂದು ಕಾರಣ ಇರಬೇಕು. ರಿಜೆಕ್ಟ್ ಮಾಡಿದರೆ ಏನಕ್ಕೆ, ಇಫ್ ಇಟ್ ಈಸ್ ನಾಟ್ ಇನ್ ಅ ಪ್ರಾಪರ್ ಫಾರ್ಮ್, ವೈ ಇಟ್ ಈಸ್ ನಾಟ್ ಇನ್ ಅ ಪ್ರಾಪರ್ ಫಾರ್ಮ್, ವೆದರ್ ದಟ್ ಕ್ಯಾನ್ ಬಿ ಅಮೆಂಡೆಡ್, ವೆದರ್ ದಟ್ ಕ್ಯಾನ್ ಬಿ looked into once again, or whether he can make changes to it. Court should look into the matter with a just view, with a view to seeing that the person should not be deprived of his right, then it can do so. So these are the things which can, of course the court has a power to reject the memorandum of appeal. Then if a decree proceeds upon a ground which is common to all plaintiffs, suppose in an original suit there were number of plaintiffs and number of defendants, and some of them go in appeal, some of them do not go in appeal. Suppose ಸುಮಾರು ಜನ ಇದ್ದಾರೆ ಪ್ಲೇಂಟಿಫ್ಸ್ ಅಥವಾ ಡಿಫೆಂಡೆಂಟ್ಸು, ಎಲ್ಲರೂ ಅಪೀಲ್ಗೆ ಹೋಗೋದಿಲ್ಲ, ಕೆಲವರು ಅಪೀಲ್ಗೆ ಹೋಗ್ತಾರೆ. ಮತ್ತು ಈ ಡಿಕ್ರಿನಲ್ಲಿ ಏನು ಬಂದಿದೆ ಅದು ಎಲ್ಲ ಪ್ಲೇಂಟಿಫ್ಸ್ಗೆ ಸಮಾನವಾಗಿದೆ. ಏನು ಡಿಕ್ರಿನಲ್ಲಿ ಅವರು ಒಂದು ಆಧಾರ ಕೊಟ್ಟಿದ್ದಾರೆ, ಆ ಆಧಾರ ಏನಿದೆ ಎಲ್ಲ ಪ್ಲೇಂಟಿಫ್ಸ್ಗೆ, ಎಲ್ಲ ವಾದಿಗಳಿಗೆ, ಪ್ರತಿವಾದಿಗಳಿಗೆ ಇದು ಕೊಡ್ತಾ ಇದೆ, ಪರಿಣಾಮ ಕೊಡ್ತಾ ಇದೆ. ಅದರಲ್ಲಿ ಒಬ್ಬ ಪ್ಲೇಂಟಿಫ್ ಅಥವಾ ಒಬ್ಬ ಡಿಫೆಂಡೆಂಟ್ ಅಪೀಲ್ ಮಾಡ್ತಾರೆ ಅಂದರೆ he can appeal, he may appeal from the whole decree ಮೇಲೆ ಅಪೀಲ್ ಮಾಡಬಹುದು. Even though that ground is the other plaintiffs are not joining, he may proceed or he may appeal from the whole decree, and then the appellate court may have an option, that is, it may vary the decree in favor of all the plaintiffs or defendants. See, what happens is, normally the person who goes to the court gets the relief. When a person goes to the court, suppose he is putting a ground before the court on the ground of which he is challenging the decree. So, it may be in his favor, that particular ground may be in his favor. It may not be in the favor of other plaintiffs, it may not be in the favor of other defendants, but he may put a put a ground before the court. Then the court normally gives him the relief. That is the normal rule. But the rule 4 is an exception to this particular principle, that that person who goes before the court gets a relief. Here what happens in Lalchand versus Radhakrishnan, All India Reporter 1977, there were a number of plaintiffs and all of them had filed a case. Later on what happened, some plaintiffs did not go for a appeal, only one lady, she goes for an appeal, and then after that this Lalchand who was there, the decree was against him actually, he dies when the pending of the appeal is there, he dies, and then his legal representatives are brought on record and they go further in the appeal. The question is, in that case what happens, the court pronounces judgments in favor of all the people, all the plaintiffs who were there. Now the appeal before the Supreme Court is that the court can give the relief only to the person who asks. So here the court says that this rule 4 is an exception to the normal rule that whoever comes to the court will get the relief. Sometimes the person may not come to the court, but still he can be given the relief by reversing or varying the decree in favor of all the plaintiffs or all the defendants, because the only requirement is that it should be, the decree should be on a common ground. Okay, it is not saying that it is in favor of the plaintiffs or the defendants, but the appellate court can do it. It can reverse or vary the decree if it wants. That is rule 4. It gives the power to the court to do it. Then in the appeal, the appellant has to give a valuation for the purpose of jurisdiction of court and court fees. Which court is having jurisdiction to treat this appeal? That is a question here. And for court fees also, looking at the valuation, money valuation, that is a pecuniary valuation, then the court can charge the fees for that purpose. For that purpose, the valuation is necessary in appeal. So as you value a suit, in appeal also it is to be valued, and looking at the value, that particular court will have the jurisdiction to try the matter. For example, if an appeal has been decided in a lower court, that is in a junior court, then the value of that suit or that the decree which has been pronounced, if the value of that is the relief which we are asking. Mainly the value is relating to the relief, not relating to the subject matter. Please remember this. See, for different reliefs there is different valuation. There is a suit fees and a court fees and suit valuation act, under which it is for every state we have that act. We have a Karnataka court fees and suit valuation act, under which for every relief the valuation is given. How much valuation and how much fees have, what is the fees to be presented or to be filed in the court. So here, when there is an appeal, the court which decides may be having a jurisdiction from which court, suppose the value of that court fees, value of that suit which is put before the court is less, but the court awards a higher pecuniary amount. ನೀವು ಕಡಿಮೆ ಕೇಳಿದ್ದೀರಾ, ಆ ಕೋರ್ಟ್ಗೆ ಪವರ್ ಇದೆ, ಆ ಕೋರ್ಟ್ ಅದರಲ್ಲಿ ಬಂಧನ ಇಲ್ಲ, ಅದಕ್ಕೆ ನಿಮ್ಮ ವ್ಯಾಲ್ಯೂಯೇಷನ್ಗಿಂತನೂ ಜಾಸ್ತಿ ಕೇಳಬಹುದು. When the court has asked that, then you have to again look into which court has having jurisdiction to treat that particular case or to take up that particular case. So looking at the pecuniary jurisdiction of the court, it has to be filed in that particular court. So from the junior court, that is a civil judge, junior civil judge, you can go to the senior division. From the junior division you can go to the senior division in appeal. Then from the senior division you can go to the district court in appeal. Or if the value is more, then you can go from the lower court directly to the district court. If it is not that subject matter is not triable in the district court, then you will have to go to the high court. See, the second second appeal lies in the high court. First appeal is normally before the senior division or before the district court. That is the first appeal. Then you go to the high court in the second appeal. So there are these stages. For that purpose, the valuation is important. Now rule 9, actually presentation of the appeal. How you present the appeal is, first of all, where do you present the appeal? Now here a question comes to our mind, because these words in rule 9, the court from whose decree an appeal lies shall entertain the memorandum of appeal. Looking at that, the meaning which we find is that the filing of appeals should be in the court which passed the decree, but that doesn't happen. That is not the case. Practically, we file the memorandum of appeal in the court which is the appellate court. But rule 9, why it is stating this is, see, this provision relating to filing of appeals is a enabling provision. It is not a mandatory provision. Basically, what was the procedure earlier is, you have to file it in the lower court. Long back, that was before 1976, that where the court is filed before that court where the decree is passed, then the high court or the higher superior court will call for those records from this particular court, and then the court will forward those records to the higher court for deciding the appeal. Now what used to happen is, as soon as you file that appeal before that court, which is the original court, the purpose is that the court should know that the appeal has been taken and it should not go for execution normally. But that is not a condition. Even though the appeal is filed, the court is not stopped from going into or from directing execution of that decree. ಒಂದು ಡಿಕ್ರಿ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಅದ್ರಲ್ಲಿ ಅಮಲ್ಜಾರಿ ಅಪೀಲ್ಗೆ ಹೋಗಿದೆ ಅಂತ ಸ್ಟಾಪ್ ಆಗಲ್ಲ. ಅದರಿಂದ ಈ ರೂಲ್ ಏನಿದೆ, ಫ್ರಾಮ್ ಹೂಸ್ ಡಿಕ್ರಿ ಆ್ಯಂಡ್ ಅಪೀಲ್ ಲೈಸ್ ಅಂತ ಹೇಳ್ತೀವಿ, ಆದರೆ ಇದು ಯಾವ ಕೋರ್ಟ್ಗೆ ಅಪೀಲ್ಗೆ ಹೋಗಬೇಕು ಆ ಕೋರ್ಟಲ್ಲಿ ಮೆಮೊರಾಂಡಮ್ ಆಫ್ ಅಪೀಲ್ ಹಾಕೋದು ಒಂದು ಇದಿದೆ, ಒಂದು ಪ್ರಾಕ್ಟೀಸ್ ಇದೆ. ಸೊ ವಿ ಫೈಲ್ ಇಟ್ ಇನ್ ದ ಅಪರೇಟ್ ಕೋರ್ಟ್. Then the court shall make an endorsement on the date of presentation, on what date that appeal has been presented, because there is a question of limitation. So you have to file it before that particular period. Therefore the amount, the date of presentation is very important, and it shall register the appeal. There is a book of appeals, that is a register of appeals, in which the court shall register the appeals. Then after that, rule 10 says that in its discretion the appellate court may ask the appellant to furnish security for the appeal. ಭದ್ರತೆ ಕೊಡಿ ಅಂತ ಹೇಳಬಹುದು ತನ್ನ ವಿವೇಚನಾಧಿಕಾರದಲ್ಲಿ. ಇದು ಏನಕ್ಕೆ ಅಂದರೆ ಅಪೀಲ್ ಕಾಸ್ಟ್ಗೋಸ್ಕರ ಅಥವಾ ಸೂಟ್ಗೋಸ್ಕರ ಅದನ್ನು ಅಮಲ್ಜಾರಿ ಮಾಡೋಕ್ಕೆ ಆಗಬೇಕು ಅಂತ ಹೇಳಿ ಒಂದು ಭದ್ರತೆ ಕೊಡಿ ಅಂತ ಹೇಳ್ಬೋದು. ಆದರೆ ಆ ಕೇಸಲ್ಲಿ ಅಪೆಲೆಂಟ್ ಭಾರತದ ಆಚೆ ಇದ್ದರೆ, ಸಪೋಸ್ ದ ಅಪೆಲೆಂಟ್ ಇಸ್ ರಿಸೈಡಿಂಗ್ ಔಟ್ಸೈಡ್ ಇಂಡಿಯಾ ಆ್ಯಂಡ್ ಹಿ ಡಸ್ ನಾಟ್ ಹ್ಯಾವ್ ಸಫಿಷಿಯಂಟ್ property within India for that particular purpose, except the subject matter, whatever the subject matter of the suit was there, which is the subject matter of appeal. Besides that, he does not have anything in India, then the court must demand, it shall demand security in such cases. It is obligatory. ಅಕಸ್ಮಾತ್ ಆ ಅಪೆಲೆಂಟ್ಗೆ ಏನೂ ಸ್ಥಿರ ಸ್ವತ್ತು ಭಾರತದಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಆವಾಗ ಭದ್ರತೆ ತಗೊಳ್ಳೇಬೇಕು ಅಂತ ರೂಲ್ 10 ಹೇಳುತ್ತೆ. Then what is the limitation for the appeal? So in CPC it does not give any limitation, but Article 116 of Limitation Act provides that when an appeal is filed against a decree or order in any other court, it is for within 30 days it has to be filed. If it is in the High Court, it should be filed within 90 days. That is a period of appeal from the date of decree or order. ಡಿಕ್ರಿ ಆಗಿರೋ ಸಮಯದಿಂದ 90 ದಿನ ಹೈಕೋರ್ಟಲ್ಲಿ, 30 ಡೇಸ್ 30 ದಿನ ಒಳಗೆ ಬೇರೆ ಕೋರ್ಟಲ್ಲಿ ಅಪೀಲ್ ಫೈಲ್ ಆಗಬೇಕು ಅಂತ ಲಿಮಿಟೇಷನ್ ಆ್ಯಕ್ಟ್ ಹೇಳುತ್ತೆ. Now rule 3A has been inserted by the Amendment Act of 1976. What used to happen is, even after that, whether the court should entertain the appeal or not, there used to be lot of differences. So therefore they have made this compulsory that a condonation of delay has to be asked when you file it after that particular period. Suppose ಆ ಪೀರಿಯಡ್ ಬಿಟ್ಟು ನೀವು ಮತ್ತೆ ಹಾಕಿದರೆ ಕೋರ್ಟ್ ಮುಂದೆ, ನೀವು ಹಾಕೋಕ್ಕಾಗಲಿಲ್ಲ ಆ ಪೀರಿಯಡಲ್ಲಿ, ಆ ಸಮಯದಲ್ಲಿ ಅಂತ ಹೇಳಿದ್ರೆ ಅದಾದ ಮೇಲೆ ನೀವು ಹಾಕಬೇಕು. ಸಿ ವೆದರ್ ದಿಸ್ ರೂಲ್ ಈಸ್ ಕಂಪಲ್ಸರಿ ಹ್ಯಾಸ್ ಬಿನ್ ಸ್ಟೇಟೆಡ್ ಇನ್ ಸ್ಟೇಟ್ ಆಫ್ ಮಧ್ಯಪ್ರದೇಶ್ ವರ್ಸಸ್ ಪ್ರದೀಪ್ ಕುಮಾರ್. Here he files it after the appeal period, but he does not, when he goes before the court, he does not give an application along with the application for memorandum of appeal. Memorandum of appeal ಮಾಡುವಾಗ ಅವನು ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಅರ್ಜಿ ಕೊಡಲ್ಲ. ಸಫಿಷಿಯಂಟ್ ಕಾಸ್ ಫಾರ್ ನಾಟ್ ಪ್ರಿಫರಿಂಗ್ ಇನ್ ಟೈಮ್, ನಾನು ಯಾಕೆ ಸಮಯದಲ್ಲಿ ನಾನು ಮಾಡೋಕ್ಕಾಗಲಿಲ್ಲ ಅಂತ ಹೇಳಿ ಯಾವುದೇ ರೀತಿಯಲ್ಲಿ ಅವನು ಇದು ಕೊಡಲ್ಲ, ರೀಸನ್ ಕೊಡಲ್ಲ. ನಂತರ ಅಪೋಸಿಟ್ ಪಾರ್ಟಿ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ ಮೇಲೆ ಅವನು ಒಂದು ಕಂಡೋನೇಷನ್ ಆಫ್ ಡಿಲೇ ಹಾಕ್ತಾನೆ, ಅದನ್ನು ತಿರಸ್ಕರಿಸುತ್ತೆ ಕೋರ್ಟ್. ಅದು ತಿರಸ್ಕರಿಸಿದ ಮೇಲೆ ಅವನು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ತಾನೆ. Supreme Court says that he has to be given an opportunity even if he has not preferred that particular application at the time of filing the appeal. See, what happens is normally when the appeal is presented, along with that you have to give the application for condonation of delay. ಈ ತಡ ಏನಾಗಿದೆ, ಈ ತಡನ ಇದನ್ನು ಮಾಡೋಕ್ಕೆ, ಕಂಡೋನ್ ಮಾಡೋಕ್ಕೆ, ಮಾಫಿ ಮಾಡೋಕ್ಕೆ ನೀವು ಒಂದು ಅರ್ಜಿ ಹಾಕಬೇಕಾಗುತ್ತೆ. ಇದು ಅರ್ಜಿ ಹಾಕಿದ್ರೆ ಅಂತ ಹೇಳಿದ್ರೆ ಅದ್ರ ಜೊತೆಲೆ ಅದು ಡಿಸೈಡ್ ಮಾಡುತ್ತೆ ವೆದರ್ ದರ್ ಇಸ್ ಎ ಸಫಿಷಿಯಂಟ್ ಕಾಸ್. ಸಿ ಇಫ್ ಯು ಫೈಲ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್, then the court will look into whether he has a sufficient cause for not preferring in time. What was the sufficient cause will be looked by the court, and the court will allow the appeal. That is the procedure. But suppose in this case he does not file, but later on he comes to know when there is an objection, he files later on. The court says that it rejects it. Then finally he comes before the Supreme Court. The Supreme Court says that on this technical matter, see, if he has sufficient cause or not, that has to be looked into by the court. The court cannot outright reject without finding out what was the cause for not preferring the appeal within time. And therefore, even though Rule 3A says that it shall be accompanied, shall word idalli, it shall be accompanied by the application, still the court has a discretion to decide whether to entertain the appeal or not. That is the case, State of Madhya Pradesh versus Pradeep Kumar. Then Rule 5, coming back, Rule 5 speaks about stay of proceedings during the period of appeal. Now what happens is, once the decree is passed by the lower court, okay, the execution proceeding starts. They need not wait for anything, they can immediately file for execution. Then he files an appeal. Suppose in the appeal it is decided is in favor, here already the execution has taken place, then he may lose his right. But that doesn't mean that just because the appeal has been filed, immediately it has been stayed. Appeal file ಮಾಡಿರೋದ್ರಿಂದ ಸ್ಟೇ ಆಟೋಮ್ಯಾಟಿಕಲಿ ಆಗುತ್ತೆ, ಬೈ ಇಟ್ ಸೆಲ್ಫ್ ಆಗುತ್ತೆ ಅಂತ ಹೇಳೋಕ್ಕಾಗಲ್ಲ. ಸ್ಟೇಗೋಸ್ಕರ ಸೆಪ್ರೇಟ್ಲಿ ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಬೇಕು ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ಗೆ. ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಮತ್ತೆ ಅದನ್ನು ಯೋಚನೆ ಮಾಡಿ ಅದನ್ನು ಸ್ಟೇ ಮಾಡಿದ ಮೇಲೆ ಆ ಸ್ಟೇ ಅವ್ರಿಗೆ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿದಾಗ ಲೋವರ್ ಕೋರ್ಟ್ಗೆ, ಆವಾಗ ಪ್ರೊಸೀಡಿಂಗ್ ಸ್ಟೇ ಆಗುತ್ತೆ. ಅಲ್ಲಿವರೆಗೆ ಅಮಲ್ಜಾರಿ ಪ್ರೊಸೀಡಿಂಗ್ ಸ್ಟೇ ಆಗೋದಿಲ್ಲ. ಸೊ in this case, Kamala Devi versus Takatmal, All India Report of 1964, it was stated that even if sufficient grounds are established, stay may be granted even if he does not apply for the stay. That was the question here, because the rights may be taken away by the execution of that particular decree. So after the appeal has been filed, what is the proceedings? See, the proceedings can be stayed under the decree by the appellate court, and the stay may be granted even if sufficient grounds are established according to this case. The application must be made without unreasonable delay. That is the reason, that is the condition which is given. That what are the conditions for the granting of the stay by the court? Rule 5 subclause 3 and Rule 5 sub Rule 4. First of all, without unreasonable delay, the application should have been made. Secondly, if this order is not made, that is of stay, then the applicant will suffer substantial loss. ಈ ಆರ್ಡರ್ ನಾವು ಕೊಟ್ಟಿಲ್ಲ ಅಂತಂದರೆ, ಈ ಆದೇಶ ಕೊಟ್ಟಿಲ್ಲ ಅಂದರೆ, ಸ್ಟೇ ಗ್ರಾಂಟ್ ಮಾಡಿಲ್ಲ ಅಂದರೆ ಅವ್ರಿಗೆ ಸಬ್ಸ್ಟ್ಯಾನ್ಷಿಯಲ್ಸ್ ತುಂಬ ನಷ್ಟ ಆಗೋದು ಸಾಧ್ಯತೆ ಇದೆ ಅಂತ ಗಮನಕ್ಕೆ ಬರಬೇಕು. ದೆನ್ ಸೆಕ್ಯೂರಿಟಿ ಫಾರ್ ಡ್ಯೂ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಆಫ್ ದ ಡಿಗ್ರಿ ಹ್ಯಾಸ್ ಬಿನ್ ಗಿವನ್. ಇದನ್ನು ಮಾಡಬೇಕಾದ್ರೆ, ಸ್ಟೇ ಕೊಡಬೇಕಾದ್ರೆ ಭದ್ರತೆಯನ್ನು ಕೊಡಬೇಕು. ಅಕಸ್ಮಾತ್ ಇದನ್ನು ಆಗಲಿಲ್ಲ ಅಂದರೆ ಈ ಕಾಸ್ಟು ಮತ್ತು ಏನಾದರೂ ಆ ಡಿಕ್ರಿಗೆ ಸಂಬಂಧಪಟ್ಟಿರೋ ಏನೋ ರೈಟ್ಸ್ ಇದೆ ಅದರ ಖರ್ಚುಗಳನ್ನು ನೋಡೋಕ್ಕೋಸ್ಕರ ಭದ್ರತೆ ಕೊಡಬೇಕು. ಫಾರ್ ಡ್ಯೂ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಆಫ್ ದ ಡಿಕ್ರಿ ಆರ್ ಆರ್ಡರ್ he should give the security. Then the court shall not grant stay of the execution so long as the court does not decide to hear the appeal on merits under Rule 11. Rule 11 ಪ್ರಕಾರ ಅದು ಮೆರಿಟ್ಸ್ ಅಲ್ಲಿ ಹಿಯರ್ ಮಾಡಲ್ಲ. ಫಸ್ಟ್ ಯು ಪ್ರೆಸೆಂಟ್ ದ ಅಪೀಲ್. The court will decide whether to hear it on merits or not. That is the procedure. It is not that just because you file the appeal before the court is not going to look into the matter and immediately take up the appeal. It is first going to decide whether the appeal is to be admitted or not. That process is given in Rule 11. So, if it decides to look into the appeal on merits, then only it will grant stay of the execution of the decree. Otherwise, it will not grant stay. That is the meaning of this. Okay. Then, if the money decree is passed, suppose there is a money decree, then no stay shall be granted unless the deposit of the decretal amount is made or security is furnished. As we said, the court can say that you deposit an amount, whatever the amount has been declared or has been decided by the original court. ಒರಿಜಿನಲ್ ಡಿಕ್ರಿ ಆಗಿರೋ ಕೋರ್ಟ್ ಏನು ಅಮೌಂಟ್ ಕೊಡಬೇಕು ಅಂತ ಹೇಳಿದೆ, ಆ ಅಮೌಂಟು ಡಿಪಾಸಿಟ್ ಮಾಡದೆ ಅಥವಾ ಅದಕ್ಕೆ ಭದ್ರತೆ ಕೊಡದೆ ಸ್ಟೇ ಆಫ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಆಫ್ ಡಿಕ್ರಿ ಮಾಡೋದಿಲ್ಲ. ಸೊ ದಟ್ ಈಸ್ ದ ರೂಲ್ 5, sub rule 5. There is an explanation that when does the stay become effective. ಈಗ ಸ್ಟೇ ಅವರು ಗ್ರಾಂಟ್ ಮಾಡಿದ್ಮೇಲೆ ಅದು ಪರಿಣಾಮ ಯಾವಾಗಿಂದ ಬರುತ್ತಂದ್ರೆ when it is communicated to that court of first instance. ಮೊದಲು ಎಲ್ಲಿ ಡಿಕ್ರಿ ಆಗಿದೆ ಆ ಕೋರ್ಟ್ಗೆ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿದ್ದೀರಾ, ನೀವು ಹೇಳಿದ್ದೀರಾ, ಅದನ್ನು ನಾವು ಅಪೀಲ್ಗೆ ಹೋಗಿದ್ದೀವಿ ಅಂತ ಒಂದು ಅವರಿಗೆ ಕಮ್ಯುನಿಕೇಷನ್ ಮಾಡಿದ ಮೇಲೆ stay effective ಆಗುತ್ತೆ. Till then the stay is not effective. Before that, if something has happened or the proceedings has gone further, then that does not affect. Okay, once the stay is effective, then the lower court cannot go forward with the execution of the decree. Now, in case of execution of decree has been appealed from, sometimes what happens, on that execution order itself, order of execution has been made by the court, from that there is an appeal. So, in that case, what is the provisions relating to security? Rule 6 says that when an order has been made for the execution of a decree, then the appellant has to show sufficient cause, and after taking security from the decree holder, the court can allow the restitution of any property which has been taken away for execution, or the court may order for due performance of the decree or order of the appellate court. What happens is, once the decree is executed, the proceedings start. Execution proceedings we will be discussing in order 21. So, according to that, the procedure starts. Once the proceedings have started, and suppose some property is there which has been taken for execution, and then such application is made to the appellate court, then the appellate court will ask the trial court to take the security. If that application is made to the trial court itself, the trial court can take a security for that purpose and restitute that property when it is stayed. So, stay ಆಗಿದ್ಮೇಲೆ ಆ ಪ್ರಾಪರ್ಟಿ ಈಗ ಎಕ್ಸಿಕ್ಯೂಟ್ ಆಗೋಗಿದೆ, ಆವಾಗ ಏನಾಗುತ್ತೆ, ಅದು ರೆಸ್ಟಿಟ್ಯೂಷನ್ಗೆ ಹಾಕಬೇಕು, ಮತ್ತೆ ಅದನ್ನು ವಾಪಸ್ ಅವನಿಗೆ ಬರಬೇಕು. ಎಕ್ಸಿಕ್ಯೂಷನ್ ಆಗೋಗಿದೆ, ಅಮಲ್ಜಾರಿ ಆಗೋಗಿದೆ, ಆ ನಂತರ ಅವನಿಗೆ ಸ್ಟೇ ಸಿಕ್ಕಿದೆ. ಹಿ ಹಸ್ ಗಾಟ್ ದ ಸ್ಟೇ ಆಫ್ಟರ್ ದ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಆಫ್ ದಟ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಪ್ರಾಪರ್ಟಿ. ಇನ್ ದಟ್ ಕೇಸ್, then he has to file for security for the restitution, and then after security being given, the lower court can take security from the decree holder and order for restitution, or can order for due performance of the decree, whatever is the situation, it can do so. Then Rule 6, sub Rule 2 says that where there is a order for sale of immovable property in execution, as we said in mortgage decree, there may be a sale of immovable property, and in that decree, when the sale has already that order has passed for a sale of property, and there is an appeal which is pending. Okay, then the judgment debtor may make an application to the court asking the court to stay the sale and give security for that purpose. Suppose he has applied for appeal and he has applied for a stay, at that time he can apply to see, because once it is sold he loses his right. So that is why this is provided under rule 6 subclause 2, that he can file an application saying that I have applied for this stay, I have applied for an appeal and the appeal is pending. On that ground the stay of immovable property may be done. For that the court will ask him for security and then afterwards it will be stayed. Then now coming to the actual hearing of the appeal. First of all, there are two things. One is the court may immediately summarily dismiss the appeal. Okay. Secondly, the court may look into the appeal and in detail the court may hear the appeal. So there are two things. Rule 11 says that when first the appeal is preferred, the appellate court will hear the appellant or his pleader. The first date will be for hearing. So it will be for hearing the appellant or his pleader, and the court looking into that, whatever they speak before the court. Here there is no question of putting evidence before the court or any details being given. They only hear on the grounds of whatever they have stated before the court. They will speak before the court. After hearing the appellant, the court it may dismiss the appeal, or if it dismisses the appeal, it may dismiss or it may post it for hearing. So if it dismisses the appeal summarily, and if it is not a high court, then it must record reasons for that. If it is a high court, not necessary to record reasons also. Just it can say appeal dismissed. There is no reason given by the high court. But if it is a other court which is an appellate court, it has to give reasons. ಯಾವುದೇ ಕೋರ್ಟಲ್ಲಿ ನೀವು ಈ ಅಪೀಲ್ ಹಾಕಿದ ಮೇಲೆ ಮೊದಲನೇ ಪ್ರೊಸೀಜರ್ ಏನಂದರೆ ಅದನ್ನು ಪಾರ್ಟೀಸ್ನ ಕೇಳುತ್ತೆ. ಪಾರ್ಟೀಸ್ ಕೇಳುವಾಗ ಅದು ಡಿಸ್ಮಿಸ್ ಮಾಡಬಹುದು. ಸಮರಿಲಿ ಸಂಕ್ಷಿಪ್ತವಾಗಿ ಕೇಳಿ ಅದನ್ನು ಡಿಸ್ಮಿಸ್ ಮಾಡಬಹುದು. ಅದು ಲೋವರ್ ಕೋರ್ಟ್ ಇದೆ, ಅದಕ್ಕೆ ರೀಸನ್ಸ್ ಕಾರಣ ಕೊಡೋದು ಬೇಕಾಗಿಲ್ಲ. ಹೈಕೋರ್ಟ್ ಇದ್ರೆ ಕೊಡಬೇಕು, ಹೈಕೋರ್ಟ್ ಇದ್ರೆ ಕೊಡಬೇಕಾಗಿಲ್ಲ. ಸೊ ದಿಸ್ ಇಸ್ suppose it calls for summary dismissal, the court calls for summary dismissal and the appellant does not appear or his pleader does not appear, then the court may dismiss for default. Just like how the suit may be dismissed for default when the plaintiff does not appear, in the same way if the appellant does not appear, the appeal can be dismissed for default on that day of hearing, that is on the first hearing itself. Then after that, under rule 19, if it is dismissed for default, the appellant may apply by sufficient cause, providing sufficient cause to restore the appeal once again. ಅದು ಡಿಸ್ಮಿಸ್ ಆದಮೇಲೆ ಅದು ರಿಸ್ಟೋರ್ ಮಾಡಿ ಪುನಃ ಅದನ್ನು ಸ್ಥಾಪನೆ ಮಾಡಿ ಅಂತ ಹೇಳಿ ಒಂದು ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದು ನಾನು ಬರೋಕ್ಕೆ ಆಗಲಿಲ್ಲ ಅಂದರೆ ನಾನು ಯಾವ ಕಾರಣಕ್ಕೆ ನಾನು ಕೋರ್ಟ್ ಮುಂದೆ ಹಾಜರಾಗೋಕ್ಕಾಗಲ್ಲ, ಅದಕ್ಕೆ ಒಂದು ಸೂಕ್ತ ಕಾರಣ ಕೊಟ್ಟರೆ ಆವಾಗ ಅದನ್ನು ಕೇಳಿ ಕೋರ್ಟ್ ಅದನ್ನು ಮತ್ತೆ ರಿಸ್ಟೋರ್ ಮಾಡಬಹುದು. ವೆನ್ ಇಟ್ ಇಸ್ dismissed for default under rule 19, it can be restored by the court if sufficient cause has been shown. If it is not summarily dismissed, then it will be admitted. How it is admitted? There is a day fixed for the hearing of the appeal and the notice is served upon the respondent with the copy of the memorandum of appeal. ಇದನ್ನು ಮತ್ತೆ ಇದು ಡಿಸ್ಮಿಸ್ ಮಾಡಿಲ್ಲ, ಮೊದಲು ಅವರು ಮಾತು ಕೇಳಿದ ಮೇಲೆ ಅದನ್ನು ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದರೆ ಆವಾಗ ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ ನೋಟಿಸ್ ಹೋಗುತ್ತೆ ಅಲಾಂಗ್ ವಿತ್ ದ ಕಾಪಿ ಆಫ್ ದ ಮೆಮೊರಾಂಡಮ್. ಸೊ ನೆಕ್ಸ್ಟ್ ಹಿಯರಿಂಗ್ ಬರುತ್ತೆ. ಇಟ್ ಮೇ ಫಿಕ್ಸ್ ಅ ಡೇ ಫಾರ್ ದ ಹಿಯರಿಂಗ್ ಆಫ್ ದ ಅಪೀಲ್. ನೌ ವಾಟ್ ಈಸ್ ದ ಹಿಯರಿಂಗ್? ರೂಲ್ 16. Actual hearing andre ಏನು? Who has the right to begin? Normally in suits, plaintiff has the right to begin. Here also the appellant has a right to begin. appellantಗೆ ಅಪೀಲ್ಗೆ ಹೋಗಿರುವಂಥ ವ್ಯಕ್ತಿಗೆ ಮೊದಲು ಇದನ್ನು ವಾದ ಶುರು ಮಾಡೋಕ್ಕೆ ಒಂದು ಆಪರ್ಚುನಿಟಿ ಇರುತ್ತೆ, ಅವಕಾಶ ಇರುತ್ತೆ. ಸೊ ರೂಲ್ 16 sub rule 1 says that on that day fixed, or suppose the court adjourns for some other date, then on that day the appellant will be heard in support of the appeal. And the court, if it finds no substance when it hears, it may dismiss at once even without asking the respondent to reply. ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ ರಿಪ್ಲೈ ಕೊಡೋದು ಬದಲು ಕೋರ್ಟೇ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೋದು ಹಿಯರ್ ಮಾಡಿ, ಅಕಸ್ಮಾತ್ ಅದರಲ್ಲಿ ಏನೂ ಸಬ್ಸ್ಟೆನ್ಸ್ ಇಲ್ಲ, ಅರ್ಥನೇ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ. ಸಪೋಸ್ ದ ಕೋರ್ಟ್ ಕಮ್ಸ್ ಟು ದಟ್ ಡಿಸಿಷನ್, ದೆನ್ ಇಫ್ ಇಟ್ ಡಸ್ ನಾಟ್ ಡಿಸ್ಮಿಸ್ ದ ಅಪೀಲ್ ಅಟ್ ಒನ್ಸ್, then it will hear the respondent. After hearing the appellant, it will hear the respondent, and after the respondent has already spoken, then the appellant has entitled to reply. The appellant can be entitled to reply means he can be after he raises some points in his objections, so then the appellant can reply to that. if the appellant does not appear when the appeal is called for hearing, now not as the first instance, here it is called for the main hearing and he does not appear, there also the court may dismiss the appeal in default under Rule 17, but it cannot dismiss it on merits. Dismiss it on default means without hearing. It cannot dismiss it looking into all the points whatever is there. Okay, it cannot dismiss it on merits. Thirdly, where the appeal has been dismissed for default for non-payment of process fees. Suppose he doesn't pay the process fees to be given or to send process to the respondent. For that the fees have to be presented by the appellant. Suppose he does not pay that and because of that it is dismissed, then the appellant may apply to restore the appeal, giving sufficient cause for not having paid the process fees, and then after paying the fees as allowing some costs on that, the appellate court will restore the appeal. ಅವನು ಪ್ರೊಸೆಸ್ ಫೀಸ್ ಕಟ್ಟಿಲ್ಲ ಅಂತ ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ದರೆ ಅವನು ಮತ್ತೆ ಅಪ್ಲೈ ಮಾಡ್ಬೋದು, ರಿಸ್ಟೋರ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ ಸಫಿಷಿಯಂಟ್ ಕಾಸ್ಟ್ ಕೊಟ್ಬಿಟ್ಟು ಆವಾಗ ಅದನ್ನು ಮತ್ತೆ ರಿಸ್ಟೋರ್ ಮಾಡ್ಬೋದು. ದಿಸ್ ಇಸ್ ಓನ್ಲಿ ವೇರ್ ಇಟ್ ಈಸ್ ಡಿಸ್ಮಿಸ್ಡ್ ಫಾರ್ ಡಿಫಾಲ್ಟ್ ಆರ್ ಫಾರ್ ನಾನ್ ಪೇಮೆಂಟ್ ಆಫ್ ಪ್ರೊಸೆಸ್ ಫೀಸ್. ಇನ್ ದೀಸ್ ಟೂ situations it can be once again restored and the court may allow him to proceed with the appeal. Where the appellant appears, respondent does not appear, if then the appeal will be heard ex parte. So without the respondent the appeal will be heard by the court. Then rehearing, now he doesn't appear, it is ex parte heard. Later on the respondent comes before the court and says that I want to hear it, I want to speak my side, and he may apply to the appellate court for rehearing of the appeal. After it has been heard ex parte and judgment also is pronounced, immediately the judgment will be pronounced. As soon as the appeal is heard, the judgment is pronounced. At that time the respondent may appear once again and ask for rehearing. If he satisfies the court that he has not been served the notice which should be served upon him, or he was prevented by sufficient cause from appearing on the date of hearing, then the court shall rehear the appeal on such terms as costs or otherwise. See what happens, Rule 21 gives an opportunity to the respondent to once again come before the court even though he has been set ex parte, because there may be some reason why he was not come before the court. There is one particular case where he did not appear before the court because he was prevented by that party itself. There was some fraud played by the party itself and they did not give a notice to him, or the notice was served in such a manner that it should not reach him, which he was not aware of, and therefore he could not appear before the court. Now the court doesn't know about it, so the judgment is pronounced. He appears before the court later on and says that this is the reason. He provides the notice, the date on which it was served to him, and also the facts on which basis he says that it has been prevented. So looking at the facts, the court comes to know that yes, there is a sufficient cause. So if he is prevented by the appellant or by some other reason, for he is not able to appear before the court, maybe that he is not able to appear because of his own incapability, or he is sick or any reason, then the court will rehear the appeal on terms of costs or otherwise. So this is Rule 21. There is one more Rule 20, that is, suppose when the appeal comes before the court finds that there is some person who was party to the suit in the trial court and he has not been made a party to the appeal. Now that person is not a party and he is having an interest in the result of the appeal. ಯಾರೋ ಒಬ್ಬ ವ್ಯಕ್ತಿ ಅಥವಾ ಸುಮಾರು ವ್ಯಕ್ತಿಗಳು ಇರ್ಬೋದು, ಯಾರೋ ವ್ಯಕ್ತಿಗಳು ಈ ಟ್ರಯಲ್ ಕೋರ್ಟಲ್ಲಿ ಪಾರ್ಟಿ ಆಗಿದ್ರು, ಪಕ್ಷಕಾರ ಇದ್ರು ಅವರು, ಆದರೆ ಈ ಅಪೀಲಲ್ಲಿ ಅವ್ರಿಗೆ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ. ಪಾರ್ಟಿ ಮಾಡಬೇಕು ಅಂತ ಅವಶ್ಯಕತೆ ಇಲ್ಲ, ಆದರೆ ಅವನು ಆ ರಿಸಲ್ಟಲ್ಲಿ ಏನು ಅದರಲ್ಲಿ ಪರಿಣಾಮ ಆಗುತ್ತೆ ಅದರಲ್ಲಿ ಅವನು ಹಿತಾಸಕ್ತಿ ಹೊಂದಿದ್ದಾನೆ. ಅಂಥ ಸಂದರ್ಭದಲ್ಲಿ ಕೋರ್ಟ್ ತಾನಾಗಿ ಅದನ್ನು ಅಡ್ಜರ್ನ್ ಮಾಡಿ ಅದನ್ನು ಮುಂದೆ ಹಾಕಿ ಅಪೀಲಿನ ಡೇಟ್ ಮತ್ತೆ ಮುಂದೆ ಹಾಕಿ ಒಂದು ಡೈರೆಕ್ಷನ್ ಕೊಡ್ಬೋದು, ಅಂಥ ವ್ಯಕ್ತಿ ನೆಸಸರಿ ಇದ್ದಾನೆ, ಅವಶ್ಯಕ ಇದ್ದಾನೆ, ಅವನಿಗೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತ ಜಾಯಿನ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ ಅವನಿಗೆ ಆ್ಯಡ್ ಮಾಡಿ. ಸೊ ದ ಕೋರ್ಟ್ ಮೇ ಅಡ್ಜರ್ನ್ ದ ಹಿಯರಿಂಗ್ ಆಫ್ ದ ಅಪೀಲ್ and direct that such person be joined as a respondent. So this is how the appeal goes before the court. So what happens is, when the appeal is filed before the appellate court, the first thing is that the court does not look into all the grounds. It looks into only the grounds which are stated in the memorandum of appeal. Okay, then it gives an opportunity to the appellant to come before the court and speak for himself, he or his pleader, of course. When they come and state the grounds before the court, and the court finds that there is no reason for allowing the appeal, there itself it may be dismissed summarily. But if the court finds that there is substance and it can hear the other party, then it will admit the appeal, and the appeal will again be kept for a date where the respondent appears and the respondent also speaks on his part. Now on hearing that also, suppose the appellant appears, respondent does not appear, then it will be set ex parte and the judgment will be pronounced. If the respondent appears or not appears, but the appellant does not appear, then also it may be dismissed for default. If the appellant does not appear, then he may once again approach the court for restoring that appeal, and it can be done by the court. If the respondent does not appear, he also can ask for rehearing the appeal after. It is called as rehearing the appeal, so that already judgment has been pronounced, therefore it has to be again brought on record and it has to be heard. That can also be allowed. So in that process, if the court finds that some other person has to be included, then the court may adjourn the case and ask for that person to be included as a party. So these are all the provisions relating to appeal when it comes for hearing. So what we have seen is that the basic thing is that the appeal has to be preferred in a form of a memorandum of appeal. Secondly, all the grounds should be set forth under distinct heads. Thirdly, the court may admit the appeal after hearing the appellant on the day fixed. It can also dismiss the appeal summarily. Fourth is, when it is admitted, the appellate court can hear or may hear after issuing a notice to the respondent. Okay, then whoever appears, whoever does not appear, looking into that appeal will be decided. So when we look at all these provisions, what we summarize is that this procedure of filing and hearing appeals, it is directed towards one thing: effective, speedy disposing of appeals, and in such a manner that it provides justice to both the parties. It does not look at only the appellant because he has got a adverse decree, or it does not look at the respondent that he has got a decree in his favor. Not looking into that, the court will first see, of course when you go in appeals, you see that the court sees that whether there is a substance in that appeal, whether the judgment which has been given by the lower court, how it is decided, and whether there is an actual reason where there is a mistake or an error of law, or there is an error of fact, or there is a mistake of fact, or there is a ground for which it can be that decree can be reversed or the decree can be modified. Then the court will look into the appeal and it will take up the appeal. After that, after the hearing, what happens? See, this is only the basic hearing. Okay, after the hearing there is another continuation, that is filing of objections. This is the only first preliminary. First, when it comes before the court, the hearing takes place and the appeal is taken into consideration. Okay, if necessary, immediately the judgment is pronounced. Otherwise, the other party may say that we want to file objections to the appeal. Now this is only heard on the memorandum of appeal, is it not? So then after that, the other party may ask for filing of cross objections. What is the procedure for filing of cross objections? What does that mean? And whether it is going to go forward just like a ordinary suit, or whether there is a difference, that we will discuss in the next discussion of this, that is cross objections in appeal. That will be our next session, where we will look into, after the appeal has been heard by the court in the beginning, then if the respondent wants to file the cross objections, what are the procedures for the cross objections? Yes, any other questions relating to this? We will be continuing this discussion in the next session. Any questions? ಒಂದು ಅಪೀಲ್ ಬಂದ ಮೇಲೆ ಅದನ್ನು ಅಡ್ಮಿಟ್ ಮಾಡಿದ ಮೇಲೆ, ಅದನ್ನು ಹಿಯರ್ ಮಾಡಿದ ಮೇಲೆ, ಅಕಸ್ಮಾತ್ ಅಪೋಸಿಟ್ ಪಾರ್ಟಿ ಒಂದು ಅಬ್ಜೆಕ್ಷನ್ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದಾಗ, ಒಂದು ಅಬ್ಜೆಕ್ಷನ್ ನಾವು ಹಾಕ್ತೀವಿ ಅಂತ ಹೇಳಿದಾಗ, ಅದರ ಪ್ರೊಸೀಜರ್ ಏನಿದೆ, ಅದರ ಪ್ರಕ್ರಿಯೆ ಏನಿದೆ, ಅದನ್ನು ನಾವು ನೆಕ್ಸ್ಟ್ ಚರ್ಚೆಯಲ್ಲಿ ನಾವು ನೋಡ್ಬೋದು. ಇವಾಗ ತನಕ ನಾವು ಏನು ಮಾಡಿದ್ವಿ ಅದರಲ್ಲಿ ಏನಾದರೂ ಪ್ರಶ್ನೆಗಳಿದ್ದರೆ ಕೇಳಬಹುದು. ಎನಿ ಕ್ವೆಶನ್ಸ್ ಆನ್ ದಿಸ್? So please post your questions, please post your comments. Okay, anything is there, you can ask me to elaborate it if you want any elaboration on any point. Okay, so we can do that in the next class. Let us stop for today with this note, that keep on sharing the hearing which we have discussed today. Keep on sharing this knowledge with your friends so that they can make use of it. Thank you.